Hello everyone, welcome to our class today. So today we are going to understand a very unique topic, that is the definition and classification of the offences. So here in this lesson we are going to learn different types of classification of the offences. So as we see, let me show you the definitions. Okay, so this is the BNSS arrangement of the sections, and section 2 speaks about the definitions. In the definitions, we may have to learn many things. Okay, under them one such important thing is different types of offences. We are going to learn different types of offences. They may be classified as classification also is done on different basis. One is bailable and non-bailable offence. Okay, bailable offence and non-bailable offence. The second one is cognizable and non-cognizable offence. And the third one, we can classify it as summons case and warrant case. Okay, I am writing it in short form, but later we can understand the actual word. So these classifications we can find. Okay, bailable and non-bailable offence, cognizable and non-cognizable offence, and sessions case and warrant case. This is one such thing. And the new additions in BNSS are, there are certain definitions, that is audio video, electronic means, electronic communication. This is regarding electronic technology. And the other important definitions are bail, okay, bail, and also bail bond and bond. So these are some of the definitions regarding bail. These are completely new additions which are not existing in CRPC. Then we have certain definitions which have been changed a little bit. Okay, those are investigation and victim definition and investigation definition. This is slightly changed. And there are certain definitions which are very important, be it CRPC or BNSS. Complaint is such definition. Okay, complaint, we need to learn that, the definition of the complaint, and also investigation, inquiry or trial. Even this we have to learn. Difference between investigation, inquiry and trial. So if we learn these many things, it will be more than sufficient. Okay, there will be a proper understanding of what it is not. All those things we can understand. So first let's understand what is bailable and non-bailable offence. Different types of offences, let's understand. These definitions were already existing in CRPC also. So same things have been continued, no change. So bailable offence, we can see before that, okay, see, you can see there are so many definitions. Okay, you can see audio video electronic means bail, bailable offence, bail bond, charge, cognizable offence, complaint, electronic communication, high court, inquiry, investigation, judicial proceeding. So many sections are there which have been defined. Okay, so we are learning only those relevant definitions which are helpful to us. We are learning only those things. So let's understand bailable offence. This one, the particular this one, let's understand. See here, this is the BNSS, this one. So bailable offence is something. First, before that, we need to know what is first schedule. First schedule is something which is given in the last of the BNSS. Okay, earlier it was given in the end of the end of the CRPC. So see here, I'll take you to BNSS. Okay, see here, this is the first schedule. This is a column, this is a table. So it has given classification of offences, and it says that, okay, it has given the offences of Bharatiya Nyaya Samhita, BNS offences are being provided in the first schedule of BNSS. So be very careful, first schedule is not given in BNS. The offences of BNSS are being provided in the first schedule of BNSS. Okay, And what does it provide? It has certain columns. It speaks regarding what section, what offense, what's the punishment, what's cognizable or non-cognizable, what is bailable or non-bailable, and by which court it is triable. So our matter of concern is this and this. These two columns are very, very important, because if they suggest bailable, we cannot decide. Okay, we cannot decide whether a case is bailable or not. Already they have been defined in this particular act. Okay, so they say, so okay, let me take you. So there is some offense. Let me take rape. So rape is a non-bailable offense. It's a cognizable case. Okay, so they have specified that it's a non-bailable offense. And there are certain other offenses also. It is bailable. So here it is, they have been made bailable. So the law has already decided. Okay, so that's why it's very, very simple. Bailable offense means those offense which is shown as bailable in first schedule, or it could be shown by other law also, like NDPS Act, UAP Act. They might say that a particular offense is bailable, particular offense non-bailable in their own act. Okay, so that is a bailable offense. What do you mean by non-bailable offense then? Non-bailable offense means any other offense other than this offense. It is any other offense which is not a bailable one. Other offenses are known as non-bailable offense. So section 2C has specifically provided what is bailable and what is non-bailable as well. It has provided both offense. Then let's go to cognizable and non-cognizable offense. So cognizable offense, even here it says that. So it says that it is a power given to a police officer. Okay, police officer, when he has to see cognizable offense, he has the power to arrest without warrant. He can arrest without warrant, but it has to be accordance with the first schedule. If the first schedule says this offense is cognizable, then in cognizable offenses, police officer can arrest without warrant, without the permission of the magistrate. He can directly go and arrest. That is the importance of cognizable offense. But in order to know that, he has to see BNSS first. He has to see, okay, whether this is a cognizable offense or not. He has to see. So the basic purpose is cognizable offense is something, it's an offense where a police officer can arrest without warrant in accordance with the first schedule, or it could be under any other law also. If they have mentioned cognizable offense, then no problem. So the ulta, this is section 2G, right? Section 2G says it so. What is the other part of this? It's a non-cognizable offense. Section 2O, what does it say? Non-cognizable offense. I suggest all of you to prepare notes then and there itself. Whatever I say, please make important points out of that. Through that you can write. Okay. So non-cognizable offense means police officer can arrest without warrant as per the first schedule of BNSS or any other law. Like that you have to write. You have to understand in such a manner that important key highlights, keywords should remain in your mind. It's not necessary that you have to write the entire definition. The keywords you have to write. Okay. So non-cognizable offense is dead opposite of that. Here the police officer has no authority to arrest without warrant. So without warrant, police officer cannot arrest him. Okay, he needs to get a warrant and then arrest a person. So that even that has been classified in BNSS in the first schedule, which is said to be a non-cognizable case. Okay, this is section 2. So what did we learn till now? We understood what is bailable offense, non-bailable offense, what is cognizable and non-cognizable offense. Both we can understand by way of first schedule in BNSS. If we directly refer to first schedule, then it is aram se we can understand. And one more thing, in cognizable offense, police can arrest without warrant. That is one important thing in cognizable case. Then comes summons case and warrant case. Summons case. So in order to understand summons case, first we need to understand warrant case. Okay. Summons case is section 2x and warrant case is summons 2z. So I suggest you, if you write it in exam first, you write the definition of section warrant case section 2z, then go to section 2x, because warrant case is something, warrant case is, it's an offense for which punishment is death punishment is there, or life imprisonment is there, or imprisonment exceeding 2 years. So more than 2 years punishment is there. So that is said to be warrant case. Okay, it means a case relating to an offense punishable with death, life imprisonment, or imprisonment for exceeding 2 years. That is said to be a warrant case. And summons case is something which is not a warrant case. So all those offences which are not warrant case, means which are below 2 years actually, they are said to be summons case. Okay, so like this we have to understand, warrant case is something where the offence is punished for death or life imprisonment or imprisonment for exceeding 2 years. Summons case is something which is not a warrant case. Ultimately it means which punishment where the punishment is below 2 years. Like that we have to understand. Okay, so these are the 3 classification of the offences what we can understand. The classification is necessary because different types of cases, summons case or warrant case, is necessary to determine the trial, what kind of trial they have to undertake, sessions trial, warrant trial, all these are necessary. And these 2 things, in order to give bail, in order to arrest a person, in order to start an investigation without warrant or with warrant, in order to decide that, we need to know what is bailable offence, what is cognizable offence, all these are necessary. Okay, so this portion is done. Then let's understand the newly added provisions, audio video electronic means and electronic communication. So first let's go to what is audio video electronic means. It has been the first definition, section 2a. So we see it's like too many things are there. So let's understand this with the help of a chart. So audio video electronic means it is something, it includes use of communication device. So in audio video electronic means what are you doing? We are using some communication device. Why is it being used? For what purpose we are using audio video electronic means? So we are using audio video electronic means for the purpose of video conferencing. Okay, it could be for video conferencing, for identification procedure, for search and seizure of the evidence, or for transmission of electronic communication, and for other purposes. So these are the different purposes what we can see. Okay, it could be for video conference, they can use, for identification process, for like when evidence is being searched, even that time you can use some communication device, or you are transmitting some electronic communication, and for such other purpose state government will through rules it may determine. So for these purposes we can say through audio video electronic means. So ultimately it is the using of the communication device for electronic communication purposes. So like that we can define it in very short. So very technical definition. Even here we can see the same thing. Okay, it shall include use of any communication devices for what purposes? For conferencing, identification, search and seizure, electronic communication, and for such other purposes. These things we can see. Then what do you mean by electronic communication? Electronic communication is something, even we see there is a lot of huge definition here, but we can understand it by way of a chart. So section 2I, what is electronic communication? It is section 2I says it so. Here we see here. Electronic communication is, see, it's a communication, it is form of some communication. What are you communicating? We are communicating some written message, okay, or you could be communicating verbal message. You are communicating pictures, or you are communicating video. So imagine you are communicating electronically by way of WhatsApp. So text, written, verbal, audio messages, picture information, image or photo what you send, or video content, you are sending video, right? So you are communicating in any of these forms. That is communication. And how are you communicating? It is being transmitted or transferred. Okay, you are transferring from one person to another, or you are transferring from one device to another. You are transferring from person to a device, or you are transferring from device to person. So it could be from person to person or device to device. So somehow you are communicating, you are transmitting it. Okay, and how, through what means are you transmitting? You are doing it by way of electronic device. You cannot do it orally. You need to have a particular device. So what is that device? So they have given the examples. It could be telephones, mobile phones, wireless telecommunication device, computer, audio video player, camera, or other electronic device or electronic form, which central government will prescribe. So these are the different types of electronic devices. So ultimately, electronic communication is something where you are communicating, okay, communicating by way of different methods, and you are transmitting or transferring that particular thing, and you are doing that by electronic device. So these are the three important. How the communication is done in this manner, how it is transferred from device to device, person to person, and which are all the electronic devices. Different examples are given: telephone, mobile phone, wireless telecommunication device, computer, camera, audio video player, etc. Okay, because nowadays so many electronic devices are there, we cannot define very, like, it needs to be elaborated. So that's why they say that central government may give a list of that. It may prescribe by notifications what are all electronic devices are included. So it can provide so. So that is the meaning of electronic communication. So I hope you have understood the definition of audio video electronic means, and also the definition of electronic communication you might be knowing. Now let's understand what is bail, bail bond and bond. These three conditions are there. Bail, so this is done, bail, bail bond and bond. Okay, so first of all let's understand bail. Bail is something, see, if you see, you can see, you might have heard conditional bail. A person is released on bail, right? Exactly. So bail is something, it is a release of a person. A person is being released. Which person? An accused person or an suspected person? A person accused of an offense or person suspected of commission of an offense. He is released from the custody of the law and is released upon certain conditions. On conditions he is being released. And who is releasing him? It could be police officer or a court. But simply they are not releasing. They are releasing on execution of bond or bail bond. So in order to get a bail, you need to execute either a bail bond or you need to execute a bond. So that one we will be studying here, bail bond and bond. Again, I am going to explain you with the help of the chart. Okay, see here, bail. Bail is something, it's a release of a person. A person is being released. Which person? An accused or a suspected person is being released. He is released from the custody of the law, and he is also released, not simply is not released. He is released upon certain conditions. Court may impose that. Okay, you have to attend police station regularly. You have to visit police station regularly. You should return your passport. You should not abscond from, you should not leave the India. So all these conditions it may impose upon the person. Okay, and who can impose? It could be the police officer or the court itself. Anyone can impose. But he is not released, like court may give order, but he must execute certain bond. He may execute certain bail bond. It depends what does the court order, whether it is bond or whether it is bail bond. It depends upon what the court says. Okay, so that is bail. So now we have to understand what is bail bond. Then we have two important things. So bail is released on the execution of either bond or bail bond. Then what do we understand as bond or bail bond? See, a very simple difference is there. Okay, bail bond is you are undertaking that, okay, I'll attend the all conditions, and along with that you need another surety. A person is needed as a surety for bail bond. Bond is something you are giving a personal bond or undertaking, but without surety. You don't require surety at all. Without surety. So on your own personal undertaking, they will take undertaking from you and they will release you. That is released on bail by executing a bond. But if the court has ordered that you are released on bail by executing a bail bond, then you need to give the surety. You have to produce the surety. Okay. So that is a simple difference. So ultimately, if I have to explain, a person is being released on bail. Okay, this is his release, but he can be released with the surety. He may be asked to produce a surety, or he may be asked without surety. He may be released without surety also. So when without surety he has been released, he is said to be released on bond. He is giving his own undertaking, personal undertaking he is giving. When with the surety he is being released, it is said to be bail bond. It is said to be bail bond. Okay. So a very simple definition, just try to understand. So the section 2b, section 2d and section 2e. Section 2b, section 2d and section 2e refer to this. So we have understood the newly added provisions. Then let's understand some minor changes which have been made in the Act. So they are with reference to the investigation and victim. So let's understand what is investigation and victim definition. So investigation is nothing, it is done by a police officer. Okay, investigation is done and it is done by police officer or who is not a magistrate. Okay, he should not be a magistrate. It could be done by a police officer or any other person. And for what purpose he is conducting investigation? For the purpose of collection of the evidence. Very, very important. Please remember, for the purpose of collection of the evidence, this is very, very necessary. So it includes all the proceedings under the Samhita for the collection of evidence conducted by a police officer or by any person who is authorized by magistrate. Ultimately, investigation is something which is done by the police officer. In a very broad manner we can state, and it is done for collection of the evidence. And the change is, what change they have made is, earlier there was no explanation, but now they have been added. What is that explanation? See here, what happens is, you may be knowing BNSS prescribes certain procedure for investigation. So BNSS is a general law. It is a general law. Whereas we also have various other criminal laws like NDPS Act or UAPA Act. Different criminal laws are there, right? They have separate investigation procedure because some may require 180 days for filing charge sheet, whereas BNSS has only 60 days or 90 days for the days to file the charge sheet. Whereas investigation, it has like more than what we can say. Other cases, they have different procedure. So in that case, police officer may get confused. Like, should I follow this method or should I follow this method? See, we all know that and all these are special laws, right? So always it is the special law will prevail. So the special law procedure have to prevail. So police officer has to carry investigation according to the special law. So this is the new clarification which has been made in BNSS. Only that is the thing. Okay. So this is the new clarification. And when it comes to the victim, next is victim definition. So a minor change have been made with respect to this of the accused person. Only this is something they have made. But section 2y, okay, section 2y says it so. So victim, who is a victim? Victim is someone who has suffered any loss or injury. He has suffered some loss or some injury. Why? Because of some act or omission of the accused person. Okay. Earlier it was he was charged, it was stated, but now just accused person, any person accused also, that is permitted. So the scope is widened by because of this change. The scope is widened. Earlier it was who accused charged with an offense, like that it was given, but now accused person, that is the meaning. So even right from FIR stage, a person can said to be a victim because accused he is saying no. So accused right from beginning only he is said to be accused. But when it comes to accused charged with an offense, then actual trial must begin. Till then he has to wait to become a victim. Already he is a victim, but in law to be said as victim, he was supposed to become, the accused was supposed to be charged. But now there is no such rule, that imposition has been removed. Just this has been properly made. So anyone who is accused, because of him, if a person has suffered loss or injury, he is said to be a victim. And that person is not only the actual victim, but also it includes his guardian or his legal heir. Very, very important, because suppose if a victim dies, okay, if victim dies, then what will happen? See, there nowadays we see that victim compensation scheme, so many things are there. So at least their legal dependents, they may get the compensation even if the victim might have died. So for that purpose, guardian and legal heir, they are also included under the definition of the victim. Okay. Yes. So this is one such thing. So we have understood the definition of investigation also, which I have stated. See, investigation includes all proceedings under the Samhita, which is for the collection of the evidence. This is very, very necessary. For what purpose investigation is done means, it is done for the collection of the evidence, you have to state. And it's conducted by police officer or any person other than the magistrate. Okay. And this is the explanation which has been added. This is the explanation. Special law prevails when there is an inconsistency in the investigating provisions of BNSS. So this is one change which we can see. And also victim. Victim is the definition. So a person who has suffered any loss or injury. Okay. If he has suffered any loss or injury because of the act or omission of the accused person, then he is said to be a victim. And victim also includes guardian and legal heir. Very, very important. So this is not a restricted meaning. This has an expanded meaning. Even guardian and legal heir of victims are also included here. Okay, this is the definition of the victim. And yes, so we have understood this portion also. Which are the different types of offences? What are the new additions made in this? And now we have also changed and we have understood what are the changes which have been made. Now let's understand what is complaint. Very, very important definition. Okay, let's understand what is a complaint. Yes, see here, complaint has been defined under section 2H. So remember these defining words. Complaint. So complaint means any allegation. Okay, complaint, usually what do we understand? Complaint is made to a police officer, we think, right? No, it is said to be information made to a police officer as per BNSS. So complaint is always made to a magistrate. Please remember, it is always made to a magistrate. Complaint means any allegation. It could be any allegation which could be made orally or in writing. Okay, it's an allegation. It's an accusation, allegation. Okay, it could be done to a magistrate. You can directly go and complain to magistrate. No need to be in writing also. It could be orally also. It could be done in orally or in writing. But why are you going to magistrate? You are going to magistrate so that the magistrate may take some action. He may ask the investigating authorities to investigate the particular proceeding, or he may do certain actions. Okay, so it means any allegation made orally or in writing to a magistrate with a view to his taking action under the Sanhita, that, like what is he going and complaining? He is saying that some person has committed an offence, right? So regarding the commission of the offence, he can go and complain to the magistrate, and it's very necessary. See here, it could be known or unknown person also. He may be knowing which person has committed the offence, or he may be not knowing who has committed the offence. That is very, very important. Okay, so complaint, if we have to summarize, it is an allegation made in writing. It's an allegation which could be orally or in writing. It is made to magistrate in order to, with a view that he may take action under this code, under this Sanhita, BNSS. And the allegations with regard to the commission of the offence. It's with regard to the commission of the offence, and it could be regarding whether known or unknown person has committed the offence. Known or unknown person has committed the offence. So this is the definition of complaint, and very particularly they have stated that it does not include a police report. Police report does not mean complaint. Very specifically they have stated. Okay, it does not include police report, because police report is something which is submitted to the magistrate. Even magistrate, police will submit report to the magistrate, which is also said to be charge sheet, or you also call it as challan, right? In this case, in such cases, what will happen when charge sheet has taken place? Okay, a person will go and give information to the police. Police will investigate the case and they will submit the charge sheet to magistrate. So even this is not called complaint. Even police submitting it to the magistrate is not called complaint. But if this person, he would have gone directly to the magistrate and he had complained, then it would be called as complaint. Okay. So very, very clearly stated, police report does not contain, it's not a complaint. But see here, there is a exception also. See, this is an explanation where they have provided about deemed complaint and deemed complainant. Okay, deemed complaint and deemed complainant. What do you mean by this? Deemed complaint and deemed complainant. Okay, I'll tell you. See, what happens is, police officer, when he gets the information, he will start investigating. Okay, only if it is a cognizable offence. He can start investigating without warrant when it is a cognizable offence. But when it is a non-cognizable offence, he does not have that much power. He cannot directly start the investigation. If it is a non-cognizable offence, he cannot start investigation. He has to take the permission and all, okay, from the magistrate. But what happened? He has commenced the investigation. He has started the investigation thinking it as a cognizable offence. But later he finds that there is a disclosure of commission of the non-cognizable offence. Okay. He thinks later it is found that okay, it is a non-cognizable offence, but I have started investigation. What to do now? He cannot sit quiet, right? He has to submit the charge sheet. He has to complete his investigation. He has to complete his charge sheet. But when he submits the charge sheet or police report, this is something which is not authorized by the magistrate, because magistrate has not authorized this. This is a non-cognizable offence. But he thought it as a cognizable offence and already has started the investigation, that too without the magistrate permission. So that's why what the law has stated that, okay, you might have started the investigation, later you got to know that it is a non-cognizable offence. So what we do, we will consider this as a complaint to the magistrate. We consider it as a deemed complaint. This police report, this is considered to be the deemed complaint. Normally police report is not a complaint, right? That we have seen here. It is not a complaint. We have seen this. But when the police officer has commenced the investigation and later it is disclosed that he has committed a non-cognizable offence, the accused has committed a non-cognizable offence, then naturally what has to do? He has to submit it to he has to take the permission. But initially he cannot take, right? So he will submit the charge sheet. When he submits the charge sheet, his complaint is said to be the deemed complaint, and the police officer himself is said to be the deemed complainant. Okay, that is the important thing we have to learn. So this is said to be a deemed complaint and he is said to be the deemed complainant. Otherwise, normally police report cannot be called as complaint. But when later commission of non-cognizant offence is disclosed in the investigation, such report is said to be deemed complaint. Such police officer is said to be a deemed complainant. Okay, so this is very important definition of the complaint. Then we have enquiry, because it is understood, these words are simultaneously told: investigation, enquiry and trial. The definition of trial has not been given, but definition of enquiry has been given. So let's understand. So enquiry is always done by the magistrate or the court. It is not done by the police officer, it is done by the court, but it is other than a trial, it is not trial. So what we can say is investigation, enquiry or trial is there. So investigation is done by the police officer for the collection of the evidence. Enquiry and trial are done by the magistrate or the court. Trial definition has not been given, but these two definitions have been given in BNSS. Enquiry is something which is not a trial. Okay, this is other than the trial, but still it is done by the magistrate or the court. So some of the examples of this are committal proceedings, maintenance proceedings. So they are not actually trial, but some enquiry court will do. So that's why that provision has been given. Okay, so these are simultaneously referred. What is the difference between investigation, enquiry or trial, like that they are given. Trial definition has not been given, but investigation reference, in investigation and enquiry, section 2L and section 2K, they have been given. Yes, okay, yes. So this was all about our important definitions which we have seen, and also the classification of the offences which we have understood under this chapter. Okay, again if you have to revise, please understand what is the basic difference between these three offences: bailable, non-bailable, cognizable, non-cognizable, summons case and warrant case, and the newly added provision: audio, video, electronic communication, bond, bail, and investigation, victim, complaint, investigation, enquiry and trial. All these definitions are very important for the purpose of the examination. They may be asked as short note also. Okay, so thoroughly understand them and make a point. Whatever I say, important points, please highlight in your book or you write it down. Then it will be easy to revise. I am saying it for the purpose of like overall how we have to study. Regarding that I am saying. So don't think about only today. So today if you are doing, if you are understanding something, prepare the notes and also write it down. Now only this could be helpful for a LLB examination, All India Bar examination, and also for a judiciary examination or for any competitive exam where this subject is involved. So make a habit of doing such notes right from now. Okay. Yes. So thank you all of you. So see you in my next video. So thank you. Take care. Bye bye.